Okay, call the meeting to order. Welcome to meeting number 59 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to House Order of March 27, 2023, the committee is continuing its study on Bill C-41, an act to amend the Criminal Code and to make consequential amendments to the other acts. Today's meeting is taking place in hybrid format, pursuant to the House Order of June 23, 2022. Members are attending in person in the room and remotely using the Zoom application. I won't go into the Zoom because I think it's only our analysts online right now, so I think we should be. We have one panelist, so I will actually go through the Zoom. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regards. So for the first hour of this meeting, actually before I go on that, is somebody missing a cell phone? Oh, okay, perfect. Okay, it's turned in. If you can hand that over. For the first hour of this meeting, we have as individuals Jessica Davis, President, Insight Threat Intelligence. We also have Dr. Leigh West, Assistant Professor from Norman Paterson School of International Affairs from Carleton University. And from Doctors Without Borders, we have Joseph Bellevue, Executive Director, and I think we have Claude Mayon via video conference. So welcome to you all. You will have 5 minutes for as individuals and 5 minutes for the group Doctors Without Borders, and then we'll commence questions right after that. So I'll go with Jessica Davis for 5 minutes.
So thank you very much for the invitation to appear here today. I want to start by sharing some information why I think these changes are important. I then have a few amendments to offer, and I'll conclude with a comment about a lingering issue that these changes raise, specifically relating to our listing of terrorist entities. So as we all know, these amendments come about because of the situation in Afghanistan, but they have much broader implications globally. I estimate that about 8% of countries worldwide have terrorist groups in them that control territory to some extent. Not the full country, of course, but some element of it where aid groups might want to operate. This legislation will, of course, enable those activities in these regions by Canadian organizations, which in turn can help increase stability and provide alternatives to engagement in violence for the people in those countries. It's important here that this amendment be calibrated with the current threat of terrorist financing. My research shows that 42% of terrorist groups around the world use taxation activities, including of aid organizations, and humanitarian activities to finance themselves. So this is not a rare activity. This is part of the reason why a broad humanitarian carve-out, as some have proposed, is much too broad in my view. It would create many opportunities for terrorist groups to exploit Canadian organizations and profit from their aid activity. The current amendments allow Canada to calibrate our aid and foreign policy to take into consideration the type of terrorist groups operating in particular regions, the activities that they're undertaking, and international security threats. This essentially will allow Canada to calibrate and turn up and down a dial on international aid according to the security situation and calibrate our foreign policy. While I do offer broad support for this amendment, there are a few areas that I think need further attention. First, I think it would be very beneficial for Global Affairs Canada to create a list of countries and geographic areas where terrorist groups control territory and provide it publicly. This would allow aid organizations to immediately be able to determine if they're covered, if their activities fall under the scope of this legislation and require an exemption. And I don't think that this is more work, because Global Affairs is likely going to have to do this kind of work anyways to effectively evaluate the applications that come through. They're going to have a list already of where terrorist groups are controlling territory. And yes, of course, there are political sensitivities around this, but I'm confident that Global Affairs can word this in a way that minimizes some of those issues. My second issue really relates to the security review, and specifically Section 10A, where the language is around links to a terrorist group. These are far too vague. Links is a term that's neither defined in law, nor is it a good analytic term. If there's something specific that the drafters of the language have in mind, they should include that here. Otherwise, the line should be struck, because it's not clear if links means something as vague as someone having known a convicted terrorist on one or two occasions, or if it's a much broader association. So specificity is going to be really key here. The third issue I see is that FINTRAC, our financial intelligence unit, isn't in the list of entities that may provide assistance to the Minister of Public Safety. And this is quite a curious omission given FINTRAC's role in counter-terrorist financing. I suggest that they are either included in the legislation itself or at least in the regulations. And further, it would be prudent to specify that FINTRAC's assistance relates specifically to their strategic analysis capabilities, which is part of the Section 58 of the Proceeds of Crime, Money Laundering, Terrorist Financing Act, which specifically allows them to provide information on the nature and extent of terrorist financing activities inside and outside of Canada, and differentiating it from their more tactical disclosures in Section 55. Finally, I want to address one last thing. The amendments, as proposed, talk about terrorist groups, not listed terrorist entities. And this language has not been lost on members of this committee. This language is a necessary inclusion because there are many terrorist groups operating around the world that are not listed entities in Canada. But I think it's important to be clear here. This language about groups is partly necessary because our process for listing terrorist entities is broken. It's not transparent. There is no identifiable methodology that Public Safety Canada uses to nominate groups to that list. And the public information provided to support those listings is the weakest in all the Five Eyes. Canada should reform the listing process with an eye to making it more robust enough to support these amendments to the criminal code, and not necessitate the inclusion of the word groups. Instead, we could use the word entities, which is actually, the word groups is far too broad to be useful. We should be able to rely on our list of terrorist entities, but we can't right now because it's not inclusive or responsive enough to geopolitical realities. So thank you again for the opportunity to be here today, and I look forward to taking any questions you have.
Thank you, Ms. Davis. And now we'll go to Dr. West for 5 minutes.
Thank you for having me. I'd like to begin by saying that I am strongly in favor of amendments to the Criminal Code to facilitate the funding and delivery of humanitarian aid and development assistance in areas that may be controlled by entities listed by the international community or the Canadian government as terrorists. The listing of terrorist entities by both the UN and in Canada is a political process. That process should not condemn those who live under these regimes to suffer from starvation or lack of medical care and education. I believe that Bill C-41 is an honest attempt to strike a balance between the need to ensure terrorist organizations do not benefit from the funds brought into these areas of control by NGOs and government agencies, and the need for NGOs and agencies to provide humanitarian and development assistance. However, I think a few amendments are required to better strike that balance. First, I believe the bill should include a humanitarian exception to the current Section 83.03 sub B of the Criminal Code, as recommended by the Standing Senate Committee on Human Rights. Specifically, this exemption could mirror the language already in the definition of terrorist activity in Section 83.01 of the Criminal Code by stipulating that Section 83.03 sub 2 does not apply to the provision of humanitarian assistance during an armed conflict, and that at the time and in the place of its provision is in accordance with customary international law or conventional international law applicable to the conflict. For those activities that do not fall within this exception, for example, education and other development type aids that does not meet the definition of humanitarian assistance under international humanitarian law, organizations could apply for an authorization as set out in the draft bill. This amendment would ensure that the direst needs of populations subject to an armed conflict could receive the most critical aid from humanitarian organizations without the added burden of those organizations seeking an authorization from the Government of Canada. Second, under the authorization regime, The factors the Minister of Public Safety may consider in their security review are vague and raise concerns under Section 2 of the Charter, namely Section 2D, which protects the freedom of association. Specifically, as Ms. Davis mentioned, 83.03210 paragraph A currently states the factor the minister may consider is whether the applicant or any person who is to be involved in carrying out the activity proposed in the application has any links to a terrorist group. It is notable that the term links is not used elsewhere in Canadian law to capture personal relationships. Rather, it is used to describe a physical connection or to describe means of communication like a video link. This novel use of this vague term in this context poses a number of concerns. First, conceivably, the term links captures any form of personal connection, however remote, between anyone within the organization and those who may assist the organization in providing aid. I've met with ISIS members in detention and work with their families to advocate for their release. Am I linked to ISIS? Humanitarian organizations often need to have relationships with all parties to a conflict to do their jobs. It is literally part of the mandate of the International Red Cross and Red Crescent. I also served in Afghanistan, and I know for a time that almost everyone in Afghanistan would have had some sort of link to someone in Al-Qaeda or Taliban to some extent. We're talking about places like Somalia, Yemen, Afghanistan, potentially Syria and Nigeria. This is not a bill designed for authorizing activities in environments like the one here in Canada, where connections to members who may be affiliated with terrorist organizations is a rarity. Lastly, the Charter protects freedom of association. It is for this reason that we do not criminalize mere membership in a terrorist organization in Canada. Denying an authorization on the basis of mere association with a terrorist group means criminalizing the work of humanitarian organizations in places like Afghanistan, where their work is most desperately needed. For this reason, I believe this subparagraph should be struck from the legislation. These two amendments would ensure a more equitable balance between security and humanitarian needs of affected populations. Ultimately, however, the success of this authorization regime will be entirely dependent on the transparency of the process and ensuring that there is sufficient resources to process applications quickly and fairly. Thank you for your time, and I look forward to your questions.
Thank you, Professor West. We'll next go to, and just, I didn't outline earlier, I usually give a 30-second cue card, but you guys have been next 4 seconds under every time, so I would thank you. And then I have an out-of-time card for those that don't know, so just to wrap things up in time. Next, we'll go to Doctors Without Borders, and I'll let you figure out out of the two of you who wants to speak, or I'm sure you have it allotted, so the floor is yours.
I will start. Thank you, Mr. Chair. For the past 52 years and today in over 70 countries, Doctors Without Borders, or Médecins Sans Frontières, MSF, has alleviated suffering through medical care consistent with the fundamental principles of humanitarian aid: humanity, impartiality, neutrality, and independence, and in line with medical ethics. MSF has no other purpose than fulfilling this social function. Here in Canada, more than 180,000 Canadians support MSF based on their trust and confidence in what we do. This allowed us to send 267 Canadians and more than $84 million to our programs around the world in 2022. Principled humanitarian work is recognized and protected by international humanitarian law, or IHL. Humanitarian organizations, such as MSF, providing essential services impartially with no commercial, political, or other objective, must be afforded the protection of IHL. Under IHL, humanitarian assistance cannot be considered support to any party to conflict, even one deemed terrorist. In other words, providing humanitarian aid cannot be considered a crime. IHL is integral to Canadian law. As party to the Geneva Conventions, Canada has an obligation to uphold IHL and must, according to recent United Nations Security Council resolutions, ensure that domestic counter-terror legislation is compatible with IHL. Canada's Supreme Court has similarly affirmed that the criminal code must be interpreted such that, quote, innocent socially useful acts, end quote, with no criminal intent are not criminalized. MSF acknowledges that Bill C-41 aims to facilitate rather than curtail humanitarian action. Unfortunately, Bill C-41 and the counter-terror parts of the criminal code it relates to are, in their current formulation, inconsistent with IHL and Canadian law, and will undermine Canadian humanitarianism. Bill C-41 would require humanitarians to seek case-by-case permission for what they already have the legal right to do under IHL. But this is not simply duplication. The process itself, in which authorization would be required from at least 2 ministries and up to 9 governmental agencies, would severely erode the practical agility as well as the principles enshrined in IHL that enable effective humanitarian aid delivery. Bill C-41's potentially onerous authorization process would divert humanitarian resources and delay our responsiveness in emergencies, like the recent Syria-Turkey earthquake, where lives hang in the balance and every hour counts. The process would also create an intelligence windfall for Canadian security agencies, including access to employee personal data that they would otherwise not have the reason to collect, and which could be used for purposes beyond the scope of Bill C-41. This will deter Canadians from working for humanitarian organizations. Further, by placing humanitarians under unprecedented government scrutiny and control, Bill C-41 would compromise our independence as well as the neutrality upon which we depend to negotiate access and gain security assurances from armed groups. Moreover, denying authorization or directing where and what activities are permitted would profoundly undermine the fundamental principles of humanity and impartiality which guide our response on human needs alone. Bill C-41 in its current form would embed a presumption of criminality in the criminal code, including for humanitarian action, by shifting the burden of proof for non-criminality onto the humanitarian actor. MSF believes this must and can be changed through a standing humanitarian exemption, clarified through relatively straightforward amendments to Bill C-41 that effectively remove humanitarian action from the scope of criminality within the criminal code. A standing exemption would be consistent with IHL, UN Security Council resolutions, other states' counter-terror laws, Canadian common law, and Canada's reputation for humanitarianism. Members of the committee, MSF worked in Afghanistan before the Taliban takeover and continued after, on the same basis that we work all over the world where state and non-state armed groups operate, international humanitarian law. MSF's purpose is solely humanitarian. For this, we should neither be criminalized nor subject to the burden of continually seeking authorization for doing precisely what we exist to do. Thank you.
Thank you. We'll now go to our first round of questions. I'm just going to condense them from 6 minutes to 5 minutes for the first round and 4 minutes for the second round in light of our pending votes that are coming up. So we'll begin by Mr. Jennis for 5 minutes.
Thank you, Chair. Thank you to the witnesses. I'm really interested in trying to understand this, but I have yet to hear a substantive argument against just a clear, simple humanitarian exemption. The most I've heard is people say, well, the government wasn't going to do that. But Ms. Davis, you, I think, on the panel expressed the view that exemption, in your view, would not be a good idea. Could you give us your thoughts specifically on why?
Yeah, so what my research shows and what I've done in practice demonstrates that terrorist groups around the world raise money from a variety of different activities, but one of the ways that they do that is by taxing aid organizations that operate in their area. That could look like, acquiring resources from them. It could look like actually taking a certain percentage of the money that comes into the country. So part of my concern with not having a broad humanitarian exemption here is a complete inability to calibrate that. So we don't have the ability to help aid organizations, for instance, prevent that from happening. We don't have a way to understand how much money or how many resources are actually going to terrorist organizations when they operate. Yeah.
And because of time, and I'm interested in hearing more from you on this, could we not prescribe as part of that exemption certain kinds of calibration, like under these circumstances you can, and under, if you're being charged an effective tax rate over such and such, you can't? Like, could we not have just whatever the rules should be? Could we not establish those rules in law rather than it being based on a potentially shifting an inconsistent authorization regime?
You could technically do that, but the problem with terrorist organizations is that they do change those rules quite often. So it's really difficult to know if in one situation is it going to be 20%, in another situation is it going to be 60%, 5%. So they really shift around quite a lot, and every situation is really different as well. So 20% might be really important in Somalia, 5% might be important in Afghanistan.
Right. Okay. It seems that you could still have, in a flexible way, some of those things defined in regulation, but still working from the principle of broader inclusion rather than individual authorization.
I think it makes sense in regulation, but maybe not in the legislation itself, because the
Okay.
regulations would be easily updated.
Okay. Both you and Ms. West referenced other countries that would be captured by the regime. Could you give us your list of 8 that you think would be
There's
captured?
8% of countries worldwide. So I don't have all of the list in front of me, but it would be things like Nigeria, Yemen, Somalia, Afghanistan, other parts of West Africa where terrorist groups are controlling territory. So it's quite an extensive list at this point.
Okay, Ms. West, in terms of the list of countries, did you agree with that? Is anything you want to add?
No, I would, especially on this, defer to Ms. Davis.
Okay, all right. Would either of the other two witnesses be interested in just responding to some of the points made with respect to the possibility of a humanitarian exemption, maybe which provides space and regulation for defining how that would be defined or not defined, but errs on the side of saying humanitarian activity, provided that efforts are made to minimize dollars to terrorist organizations, would be allowed?
Sure. I mean, I think it's the starting point here is that international humanitarian law already, gives the protection and already says that when you're operating in an area where there are armed groups, whether deemed terrorist or otherwise, even in situations where you might have to pay these sort of administrative fees or landing fees or whatever it might be, that kind of activity is authorized because the humanitarian imperative exists and we need to be able to respond to it.
Okay. Do you want
I would 100% agree with that. The idea that humanitarian assistance legally if you're going to provide a humanitarian exception based on consistency with international law and then put domestic regulation on top of how you're interpreting international law doesn't make a lot of sense to me. If it's going to be lawful because it's lawful under international law, then that should be the limit.
Okay. Just in the time I have left, the definition of terrorist group in the criminal code, as I understand it, does not clearly exclude state actors. So some might argue that, for instance, Iran is a terrorist-controlled territory. Is it clear in the way the law is currently written whether or not it would apply in cases where the government of a state is not a listed entity but has the attributes of a terrorist group?
Very quickly.
I would say that the legislation would apply in those contexts, but then you're asking the humanitarian organizations to make that determination, which I think, as MSF mentioned, goes against their role to remain impartial and neutral.
Thank you. Thank you, Mr. Jenius. Ms. Damas, for 5 minutes.
Thank you, Chair, and thank you to all our witnesses for being here. Mr. Beliveau, in particular, thank you for the work that you and MSF are doing, not just in Afghanistan, but around the world, saving lives, and we all appreciate it. That we're really challenged with this, and Monsieur Brunel de Sepp and I both sat on the Special Committee for Afghanistan, and struggled with the fact that the Taliban are listed in our criminal code. In other countries, it's been mentioned before that there was a blanket exemption given. Our understanding was that we were unable to do that because of the way the Taliban is listed. Just today, there's an article that the U.S. Afghanistan watchdog testified before Congress that he can't guarantee that U.S. aid is not going to fund the Taliban. So trying to strike that balance. Ms. Davis, maybe I saw you shaking your head when I talked about the criminal code. Could you maybe explain and talk a little bit about the challenges we have in trying to get this exemption to get aid into Afghanistan?
When we do a comparison with other countries, it's important to remember that not every country, all of the listing processes are quite different. So the United States doesn't have the Taliban listed in the same way that we do, so they can apply broader exemptions in a different way. But I think your point is exactly right. Like, there's no way to guarantee that money or resources going into Afghanistan is not going to the Taliban. And in fact, I would say the opposite's true. I can almost guarantee you that there is money and aid going to the Taliban because that's how they operate. So it's really about striking the balance between how much we think is appropriate and how much isn't, which is part of why I was talking about calibrating our foreign policy, because sometimes we might find that to be acceptable, other times we might not be, depending on how the terrorist group is operating internationally. If the Taliban starts having external attack capabilities and aspirations, we might want to turn the dial down on how much aid is going to that country.
Yeah, but having said that, even if it's not external, when I look at what's going on in Afghanistan, it's horrific. It's one of the worst in the world right now, in terms of the people who are the millions there. My other concern, and it was actually something that Ms. McPherson brought up at our last meeting, was how do we ensure that this legislation is not politicized, so that a government can't say, okay, we're going to make sure to include, and I'll just use this as an example, Gaza, and we're going to ask you to apply, and then we're going to sit on your application for 2 years, and so you're unable to deliver aid. And that's just, I mean, it could be Nigeria. You listed, through you, Mr. Chair, Ms. McPherson listed a number of countries. So is there anything that we could change in this legislation to ensure that it can't be politicized? Maybe Ms. West and Ms. all of you can respond.
So all listing regimes are political processes, right? It's a government decision. In Canada, it's a decision by the Minister of Public Safety that recommends it to the GIC. So it's not a legal decision in the sense that it is a political process, same within the United Nations. So you're asking humanitarian organizations to recognize the political listing of a terrorist organization by the Government of Canada, recognize that, and then apply to nevertheless go and do their otherwise lawful activity in those regions. So I don't think that there's a way around it except for saying that those humanitarian organizations can continue to do their lawful activity under international law, which is why I think that an exception for humanitarian assistance that complies with IHL, right, so that's neutral and partial, is permitted under the criminal code. Listing is inherently political. And so any recognition of a listing is going to legitimize that political process.
This legislation goes further than just listed entities, though, right?
It does, and that's another problem, because you're asking a humanitarian organization to apply facts, so contested facts, to our criminal code definition and come to a decision about whether or not they think that the organization controlling the area they're working in is a terrorist group, which is a challenging process, even for the RCMP. So I think that request is also a bridge too far, and I would like to see the legislation specifically say only those that are listed entities, because I think that request on humanitarian organizations, again, is asking them to make a determination about whether a group in a controlled area is terrorist.
Do either of the other witnesses want
Sure.
to? I only have a few seconds.
Sure. Just maybe to build on it, I think there's a high risk of politicization on both sides of the fence. So a high risk on this side. So once you start this authorization process and we have to submit all this information to all these government agencies, there is a risk either now or in the future that could be used for purposes beyond the scope of what Bill C-41 is about. On the other side of the fence, the way we get perceived, we depend on neutrality and the perception of neutrality and being consistent with impartiality. If we're perceived as not holding up to those principles, we're not going to be able to negotiate our access in places where listed or otherwise armed groups are operating. And so you could get politicization on both sides.
Thank you. Thank you, Ms. Damos. Next, we'll go to Monsieur Bernal Duceppe.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to everyone who is here, all our witnesses. You know, the first disappointment with this bill is that it took far too long to get to this point. I think we all agree. There are several MPs with the government and on the opposition side that have worked very hard on this, but it put too long. And now we're in a difficult position where I want the problem to be dealt with as quickly as possible. The main goal, I think, of everyone here is that these countries be able to access the humanitarian aid that they need as quickly as possible. So either we decide to really get into the technical aspects of this bill, the administrative aspects, or we take another approach and we go for the humanitarian exemption. In your opinion, what is most important? Finishing this more quickly to vote on it, or should we really change it and try to add this humanitarian exemption? Mr. Belvaux?
Thank you for the question. I mean, I think it's pretty clear from what we've been saying so far that we think that an exemption is possible. That is the way to go. We think that it could be expedited relatively simply. If you back up a little bit, this problem has existed since the Anti-Terror Act was put in place in 2001. That created this ambiguity because already then there wasn't an exemption carved out for humanitarian action. So humanitarian actors were left questioning whether or not they might run afoul of the criminal code for all these years. Now the stakes are raised. The government has come forward and said, we think we have a solution here. We don't think Bill C-41 is the right solution, but we do feel that you could introduce language within Bill C-41 that would actually clarify, all the way back to the Anti-Terror Act, would actually clarify that we respect IHL, which Canada clearly does, that we respect IHL, and so when humanitarians are operating in an IHL context, they will not run afoul of the criminal code. So.
And I'm 100% in agreement with you, but I have to say it, we are MPs from different parties and we might not all agree on that. And one of the issues that I have is that I do not want to see us filibustering in this committee because we don't agree on what's being said, or maybe we do agree, but the Minister of Public Safety has decided that it's not acceptable, and then the procedure is blocked. We can't find an agreement. And as this is happening, well, we have people who are not getting the aid that they need, which, like I said, is the ultimate goal of this bill. So could we potentially come to an agreement, strike a balance in order to find a solution as quickly as possible? And as a parliamentarian, I'm trying to see, as humanitarian organizations, what you think is acceptable. What could we do? Do you think that, for example, there could be exemptions for NGOs that are very credible, that have a lot of experience, that are already on the ground? Could we have a list of NGOs that are already exempted from this? Do you think that could be possible as a suggestion to the government? We could add it into the bill, or do you think that's impossible? And anyone can answer.
Oui, tout le monde peut répondre.
Merci. Je vous remercie.
Thank you. Thanks for the question. I understand your concern with moving ahead quickly. So you mentioned this list of different organizations, and I think what's important today is that we distinguish between different types of organizations that are concerned by this. So firstly, we have impartial humanitarian organizations, such as Doctors Without Borders or the Red Cross. And these are organizations that are trying to support countries that have been affected by war, for example. And these are organizations that respect IHL and the Geneva Convention, for example, in offering humanitarian aid. And so these impartial organizations have rights to protect these humanitarian rights, humanitarian rights. And so what we're trying to do through the charter and through funding is to make sure that we are respecting these fundamental needs that are laid out in international humanitarian law.
Vise à promouvoir et qui ne répondent pas forcément aux mêmes besoins.
And these, oftentimes we have a,
Next, we'll go to Ms. McPherson for 5 minutes.
Thank you, Mr. Chair. 5 minutes is very short. First of all, I'd like to thank our witnesses for being with us today, and certainly I'd like to thank you for the work that you do and for raising, in particular, Ms. West, the humanitarian context that these things are happening in. I think sometimes that does get lost when we start to talk about the law, is that we are not doing this in a context. This is not happening in a context where it is easy to work. This is happening in contexts that are very, very difficult. So thank you. I'm going to start by asking some questions of MSF. MSF was the very first organization I ever volunteered with, so has a special place in my heart. I was 19, so it was a very, very long time ago. I did read the brief that you provided to the committee, and in your brief, you refer to the fact that the current authorization regime in Bill C-41 may also pose security risks to Canadian humanitarian staff working for organizations like MSF. You spoke a little bit about that in your testimony. Can you elaborate on that for me, please?
So the risk to staff, as MSF, like as any organization, we have a duty of care to staff. And so the way that this Bill C-41, the authorization regime, is set up, it poses risks to individuals in that the sharing and providing of personal data and information in a way that we don't know how that information will be used, we don't know where it will be stored, we don't know how many agencies will have access to it, will pose at least unknown risks to our staff. And we know from just even the feedback that we've had since Bill C-41 came out, that we know that staff working for MSF will be deterred from wanting to continue to work for the organization because they don't know where their personal data will be stored, used, and for what purposes.
Thank you. In your brief as well to the committee, you make a strong case for a permanent standing humanitarian exemption, of course. We within the NDP will be bringing forward a recommendation or an amendment to do that. And you have provided the draft language for that. My understanding that this is something that the International Committee of the Red Cross has also called for. Can you talk about other organizations that have been supportive of this amendment? And I should also mention, by the way, that Ms. West, that your amendment on the language on the terrorist entities is something that we also will be bringing forward.
Claude, do you want to speak to that with ICRC and maybe others?
Thank you. Sorry. Yes, sorry, I had a problem with the microphone. Maybe also I wanted just to mention also on the security of Ms. McPherson law is that by undermining also the principle that I just mentioned, impartiality, neutrality, this is the principle that grants an access to population, but that's also the principles that grants us the protection under the Geneva Convention. This authorization process will further increase security risk for MSF in the field because those fields are volatile contexts. And in these contexts, we will be wrongly presented as MSF as agent of the Canadian state. And it would be wrong because we are neutral and impartial. And through that authorization process, we would appear as agent of a country. So a state that has maybe publicly designated some non-armed state armed groups as terrorists or call for their arrest. And at the same time, per Bill 41C proposal, it will also give its approval stamp to impartial humanitarian organizations such as MSF to carry out or not their activities in territories controlled by these very same armed groups. So attacks could actually also target humanitarian personnel from organizations which so far appeared as neutral and impartial, but might no longer appear as such under such authorization process implementation, while rather be presented as linked to state diplomacy or politics. So this will clearly also be a massive risk for Canadian humanitarian, but not only Canadian, but included Canadian.
Sorry, just to clarify, what you're saying is that not only will it put organizations, individuals at risk because they will be associated or as an agent of the state, it may also, I assume, impact the ability of organizations, humanitarian organizations, to get to locations in the first place.
Absolutely. Absolutely.
Yeah, thank you very much. One other question for you. Can you explain the difference between exclusively humanitarian organizations and activities that are covered within the legal framework of the IHF and those other mandates to do things such as development or peacekeeping work that is not covered by the IHL? Sorry, I don't think that perhaps this committee has a strong understanding of that.
Well, I can talk about that indeed, and I think it's a little bit also in the same sense that I answered to the previous question. Is that we understand that there are very specific organizations that are considered as neutral and impartial, such as MSF and ICRC, because they are acting under the mandate that is confirmed by international humanitarian law. Not all the organizations that are working for peace building or for humanitarian aid development or peace building are answering to IHL requirements, because to actually be active under IHL and to be under the Geneva Convention or customary law, you need to respect those principles of impartiality, humanitarian organization. And because of that, you are allowed to make some offer of services to parties to the conflict who are free to accept it or not, and who are actually under the only reason for refusing it, except that there would be no need,
Thank
would
you.
be to actually consider that this organization is not impartial.
Thank you, Ms. Moon. Thank you, Ms. McPherson. We'll now go to a round for 4 minutes with Mr. Van Popta.
And I'm going to share my 4 minutes with my colleague, Mr. Janis. He'll start off.
Okay, thank you, Chair. So it seems like one of the concerns about a general humanitarian exemption is the possibility of you have a terrorist organization controlling an area, and they say you can bring in humanitarian assistance, but you've got to pay 70% tax, right? So you're getting some money to people who are suffering, but most of the money is going to the government, to the authority. We probably wouldn't want quote unquote humanitarian assistance to go in that case because the price is simply too high in terms of who receives it. On the other hand, there would be other parameters and other circumstances where we would think that would be reasonable. So I'd like to hear from those that are in favor of a general humanitarian exemption, what you think would happen in the hypothetical case I've described, or should happen.
What would happen in the hypothetical case where an exorbitantly high demand for taxation? Is that your question? Yeah. MSF and other humanitarian organizations, we've been doing this for 52 years now, in all sorts of contexts where armed actors are present and operating. It is part of our job, and it is consistent with providing aid to people who need it most, that we're constantly negotiating with these armed groups in a way that minimizes, the figures that you're talking about are not figures that we would ever agree to. We're constantly negotiating to the least amount of any sort of benefit whatsoever that's going to accrue to an armed group. By far, the majority of what we provide goes to the people that we're there to assist.
So just to follow up on that, you're a trusted, credible organization, and so saying, hey, we know what we're doing here is reasonable in your case. A broad humanitarian exemption wouldn't just apply to organizations like yours. It would apply to organizations that maybe have good intentions but don't have the same track record. So how, if we want to say yes to you in that case, but want to be cautious about others that may not have the same experience, how do we do that?
Again, this comes back to what Claude was saying, and I'm sure she can build on this. She's clearly saying that an organization that is operating according to the humanitarian principles and providing aid impartially has the protection of IHL and already has then the right to intervene and to provide that service. Now you're talking about the practical negotiations after that, but we have the right.
I'm sorry, I want to honor my colleague's generosity with his time and give him a little bit.
Okay, thank you. Mr. Beliveau, I'll direct my question to you, my very short question and short answer. There's concern has been expressed that the government has been slow in rolling out this Bill C-41. We knew that there was a humanitarian crisis in Afghanistan, but other places as well. Has your organization been adversely affected in any way by that delay? Have you been prevented from doing some important work that your organization typically would have done had Bill C-41 been in place a year ago?
So because we are so firmly committed to the humanitarian principles, and because we are so firmly under the protection of IHL, we know this, we have the experience of it. We did not alter our operations in Afghanistan, nor have we altered them anywhere else.
So have you been operating in Afghanistan even though it's governed by the Taliban?
Yes, before the
seem to
Taliban
be-
takeover and after the Taliban takeover, again, under the protection of international humanitarian law, yes.
Okay, so I have a question about that. Like, isn't that doing indirectly what we can't do directly under current Section 83 of the Criminal Code? How do you work around that through IHL?
I'll add, and I think Claude maybe can jump in on here, but maybe just to back up one. There are a lot of other organizations now, again, active in Afghanistan because other states have already made similar kind of exemptions to the one we're talking about here. The United Nations Security Council has not only called for counterterror measures to be in line with IHL, but has actually made resolutions that provide these kinds of exemptions, including in Afghanistan. So it is possible to do this, and a lot of other organizations and states behind those organizations are moving in that direction. Maybe Claude wants to build on that.
Sorry, unfortunately, we're out of time. The last question will go to Ms. Diab for 4 minutes.
Thank you, Mr. Chair, and thank you very much to our witnesses, and thank you to you and your teams, really, for providing this necessary humanitarian work across the globe. I can only imagine, what your organization and the people that are employed or volunteering there go through to get to that. So this is the second day that we hear on this bill. We heard that the bill is crucial to provide humanitarian aid in Afghanistan. But of course, as you've said, it's not simply Afghanistan. It could be anywhere and many other places around the globe. We also heard, obviously, from government officials and others that there's a balance that needs to be struck here. And in law and in reality and just in life, it's always very difficult to strike balances, but it's always something that you attempt to do, I suppose. Miss West, you have extensive experience in Afghanistan, but also in what you've done personally. Can you talk to us a little bit more about the security considerations? How would you factor those in the provision of foreign aid?
So I think IHL, which governs humanitarian assistance and the work that humanitarian organizations has already factored in a lot of that balance. And so there are a series of requirements placed on these organizations in order to lawfully provide aid inside an armed conflict, which is what we're talking about when we talk about a humanitarian exception. And so in that case, in an armed conflict, IHL already permits people to kill other people, right? This is the balance for humanitarian aid to help those people who might be killed. When we talk about the security balance now, we're talking about funding to terrorist organizations versus the ability to carry out that humanitarian aid. So you're adding an extra layer against humanitarian aid. And I'll go back to the question before, is how is MSF doing what they're doing? Was because Canadian criminal law should be interpreted consistently with international law, which includes international humanitarian law. So you could already read a humanitarian exception into the law, but it's hard to do given some of the other language in the Act. But MSF is doing it in order to carry out their work. So I think relying on IHL and relying on an exemption that's based on IHL already factors in that security balance and and the humanitarian balance. We're trying to do it on top by saying, well, this organization, this armed group is a terrorist group, so therefore it's even more important that we not fund it. But any armed group, right? Like, we already have to worry about any armed group that's killing civilians, right? Like, so I just think that the balance is a little bit off by not recognizing the work IHL already does to protect that balance.
30 seconds. Ms. Davis, would you, in 30 seconds, like to add anything on that?
The only thing that I want to add on that is that this bill, to me, strikes the important balance of recognizing the reality on the ground, which is that when international aid organizations operate in conflict zones where terrorist groups are operating, they are going to be providing them funding. There's just really no two ways about it. I think that it's important for the state to have the ability to calibrate how much we find to be acceptable and in what circumstances.
Thank you. Thank you, Ms. Diab. Thank you to all the witnesses. I want to really thank you and apologize for having to cut it short. We have to adjust two panels and have votes in between as well. So thank you. I will suspend for 60 seconds, and then I'm going to have the next panel up. Thank you. Our study on Bill C-41. We now have Shabnam Salahi as an individual. We have Osama Khan, Chief Executive Officer of Islamic Relief Canada. Welcome. We have from World Vision, Martin Fisher, Head of Policy, and we have Amy Avis, Chief of Emergency Management and General Counsel. I think they'll be sharing their time. And we don't have anybody online. I think it's all in person. So we'll begin with Shabnam Saleh for 5 minutes.
Dear Mr. Chair and member of the committee, I am honored to have the opportunity to express my opinion regarding the Bill C-41. I am Shabnam Saleh. I was a Women Rights Commissioner at Afghanistan Independent Human Rights Commission, and beside that, I was a lecturer at Kabul University. Now I'm a visiting lecturer at the University of Ottawa. In my opinion, the bill will grant the Canadian government the necessary permission to effectively address the ongoing crisis in Afghanistan. As you all are aware, Afghanistan is facing a humanitarian crisis that is affecting millions of people. According to OCHA, 28.3 million people have been found to have a severe food insecurity. Near 19 plus 9 million people suffer from the acute hunger. According to UNDP, as of May of 2022, almost 97% of Afghans were living below the World Bank $1.90 per day international poverty threshold. Additionally, poverty in Afghanistan is likely to become even worse. Before the August 2021, Afghanistan economy was 75% dependent on the foreign aids. According to World Bank, a repeated reduction in international grant support, loss of access to offshore assets, and disruption in the financial ecosystem are expected to lead a major contraction of economy, increasing poverty and microeconomy instability. The de facto authority has been continuing to engage in discriminatory action against women, exemplified by the Taliban, and justified ban on girls' education. This ban is a result of the Taliban extremist ideology, which is promote gender apartheid and seeks to exclude women from the social life. The Taliban gradually enforced the ban through a series of decrees, starting from the prohibition of male teaching for education girls, followed by the implementation of gender-segregated classes, and ultimately the closure of the secondary education for girls. Additionally, the Taliban limited women's ability to choose certain academic fields, eventually prohibited female university students from pursuing higher education. This further accelerates the issue as women are prohibited from working, including the UN agency. As the beginning of this week, the Taliban has extended this crackdown as a woman education by closing primary school in 4 provinces of Afghanistan. Canada faces a crucial decision to make, whether to permit the oppressive regime in Afghanistan to continue their discriminatory practice or take affirmative action to counter their supervision. Specifically, by empowering the women, the people of Afghanistan, especially women. If Canada opts for the latter, I think the proposed bill allows a blueprint for the implementing, executing, and assisting the response under the current regime. I believe this bill will present a viable path forward by providing a plan to support the Afghan people, particularly women. My request to the committee is to ensure that the bill prioritizes the empowering of women, social mobilization, and civil movement as a means of confronting the discriminatory policies imposed by the regime. To achieve this, I propose the bill strongly emphasize as distribution of aid toward the women empowerment, protection and promotion of human rights, and widespread social mobilization. To achieve this mission, I believe the subsequent legislation policies, programmatical intervention would align Canadian diplomatic and humanitarian assistance with the other alliance to accelerate pressure on the regime to change their discriminatory policies. This will provide Canada with the opportunity to actively engage in the process of the empowering and supporting the people of Afghanistan toward a positive change that align with the Canadian core interests and international commitment. By working in cooperation with the other alliance, Canada can pull out resources and effort toward the shared goal of creating a major, just, and equitable society in Afghanistan. This will also provide an opportunity for Canada to showcase its leadership in promoting human rights and gender equality globally. Thank you so much.
Thank you, Ms. Salehi. Next, we'll go to Osama Khan for 5 minutes.
Thank you so much, Mr. Chair, and members of the committee. My name is Osama Khan. I'm the Chief Executive Officer at Islamic Relief Canada, which is a member of the Humanitarian Coalition. Since 1999, Islamic Relief globally has been operational in Afghanistan and throughout the current last 2 years as well. Recently, the UNDP selected Islamic Relief as an implementing partner for a $22 million project, recognizing that it can deliver in Afghanistan in an effective, transparent, and accountable way. I want to start off by acknowledging how proud I am of the Aid for Afghanistan Coalition, with including Red Cross, World Vision, and many other agencies to come together and encourage legislative change on this important area. And also must acknowledge that it was through public mobilization and tens of thousands of people across the country being interested in Canada's position on this that I think is the reason that we're here speaking about this today. And for me, that is the true power of democracy. The current language in Bill C-41, we feel that there's some unintended consequences that may actually move us backwards instead of forward. And continuing on the discussion from the last session, I wanted to add kind of a few perspectives from our experience working in Afghanistan. The question of how much aid or how much taxes goes to countries, I know figures, hypothetical scenario of 70% was raised in the question and answer, and maybe I can give some tangible examples from this crisis. In 2021, in the summer of 2021, when the Taliban took over the government, we wanted to understand, as Islamic Relief, our risk appetite, and so we figured out and calculated what the taxes were, and it was around 3%. And so what we did at Islamic Relief was, because the UK and the US, our counterparts, do have broader humanitarian exemptions, we wanted to continue helping the people of Afghanistan with Canadian donor funds that our donors from across the country wanted to give for Afghanistan. And so we carved out the 3% that was for government taxes, and our counterparts in the UK subsidized that portion. So no Canadian funds were being used that went to the government. But just to give an example, that agencies like Islamic Relief have very robust policies, anti-diversion policies, anti-bribery policies, and so to give them the space to make those decisions, operational decisions on the ground, that will be reasonable and accountable. I think the administrative burden, placing the administrative burden, additional administrative burden on charities as part of the authorization regime is something that would be onerous and would take the onus. The onus should be on the government to decide which organizations are listed, and not on the charities to do that themselves. And secondly, I think the process of the authorization regime, particularly around the risks of terrorism financing, I wanted to spend a few moments on that. In terms of securitization of humanitarian aid and looking at Canada's updated inherent risk assessment for money laundering and terrorism financing, which was released a few weeks ago, it mentions, and I quote, "The government must be vigilant to avoid systemic and unconscious bias influencing how it is applied." So I think There's some language in the bill with respect to what we heard about the vague word with links that I think now or in the future can be used as a political tool and can be used to have a chilling effect on the humanitarian sector. I think it's important that we look at the oversight, transparency, and accountability measures that would be in place as part of the authorization regime in approving these things. Just in conclusion, this is an important step. This discussion is an important step, but we want to make sure that the unintended consequences don't outweigh the benefit that we're trying to achieve. Thank you so much.
Thank you, Mr. Khan. Next, we'll go to Mr. Fisher and Ms. Amos. You can split your time accordingly.
Thank you, Chair. Honorable members, thank you for inviting us to appear today on your deliberations on Bill C-41. My name is Martin Fisher. I'm the head of policy for World Vision Canada, and I'm joined by my colleague Amy Avis, who's the chief of emergency management at the Canadian Red Cross and also a much more qualified lawyer than I will ever try to attempt to be. We're joining you from Ottawa, which is on the unceded territory of the Algonquin and Anishinaabe people, and our organizations are both members, as Usama has mentioned, of the Aid for Afghanistan Coalition, a diverse group of Canadian humanitarian aid, human rights, and women's rights organizations that have operated in Afghanistan for decades. Today, we're speaking to a submission that was jointly prepared by 8 organizations. I do want to emphasize that over the past months, and in fact longer than a year, we've closely engaged with parliamentarians from all parties, many of you around the table, as well as officials and ministerial staff from many departments, and that dialogue has been exceedingly constructive throughout. So thank you for that. Before Amy details some of the legal considerations of our submission, I want to stress 3 points regarding Bill C-41. First, as you progress through these deliberations, you'll hear, as you have, a spectrum of views on Bill C-41. We believe that with some fine-tuning, it is a critical step forward in a longer-term journey to ensure that Canadian humanitarian organizations, as well as those delivering other services in these difficult contexts, can operate in a neutral, impartial, and independent manner in the most difficult and exceptional circumstances. Second, Bill C-41 applies to a very narrow, again, exceptional set of contexts in which interaction with the terrorist group exercising control over territory is wholly unavoidable. Third, while Bill C-41 is not specific to just Afghanistan, it can enable us to resume work in that particularly challenging context, hopefully in the very short term. We cannot lose sight of the severity of the humanitarian crisis there and the obligations that Canada and Canadians have to help. I'd like to turn it over to Amy now, who will outline some of our legal perspective and recommendations contained in the submission.
Thank you for the opportunity to speak with you this evening. A core belief of the Canadian Red Cross, as well as our sector partners, is that no one should be blocked from receiving humanitarian assistance on the basis of location. We believe that Bill C-41 is a critical step forward in a longer-term journey to protect the provision of neutral and impartial humanitarian assistance. If implemented, put simply, it will enable Canadian aid organizations to resume operations in Afghanistan and conduct its operations in complex contexts across the globe. I would like to focus on 4 recommendations today. The first is expediency. The second is alignment of the amendments to the purpose of the bill. The third is ensuring that the authorization regime is fit for purpose. And the fourth is the commitment to the longer-term journey that my colleague referred to. In terms of expediency and implementation, all of us are aware of the staggering need for humanitarian assistance in Afghanistan. No one would like to see a second anniversary come to pass where the Canadian aid organizations who desperately want to deploy their resources, Canadian expertise, and support to those who desperately need it. These programs are vital for improving access to health care and other life-saving assistance, in particular for women and girls. My second submission is with regards to alignment of the amendments to the bill. We've heard many discussions earlier this evening in terms of recommendations, and we agree with a lot of them that have been discussed. But what we would say is that the bill is intended to address an exceptional set of circumstances and rare context in which interaction with a terrorist entity is wholly unavoidable. And so it isn't about just the context of Afghanistan, but it is around narrow exceptional circumstances globally. So to better support this intent, one of our strongest recommendations is to use the language of substantial control rather than sufficient control. Finally, although there is a need for further clarity in the language of the bill, any revision must guard against the unintended consequence of increasing the breadth of application of the authorization regime. Which brings me to my third point, which is ensuring that the authorization regime itself is fit for purpose. The coalition has chosen to focus on the implementation of the authorization regime because we feel as though this is where the rubber is going to truly hit the road. And so beyond amendments to the bill itself, this is something that we can't lose sight of. We believe it has to be clear, fair, consistent, practical, expedient, reasonable, and resourced. It also has to keep pace with operational realities. The last is the most important time, and I see my time is up, so I will be brief. It's the commitment to the longer term journey. This is a step, this is a building block, it isn't everything, and as long as we're committed to the longer term journey that needs to be taken forward to systematize the provision of neutral and impartial humanitarian assistance, we strongly support the recommendations of this bill.
Thank you, Ms. Davis, and thank you, Mr. Fisher. Members, bells have started ringing, so if I have consent, if we can go till 6 p.m., and then you have about 10 minutes for those that want to go in person, and then there are some members that want to vote in person, and then we'll resume 10 minutes after the vote is the result is cast, if that's okay. So do I have the consent of the? Yep. And then so we'll come back. After that time, 10 minutes, we'll start right away. And we have services till 7 p.m., just so you know. Okay, we'll go to our first round for 5 minutes, beginning with Mr. Genis.
Thank you, Chair. So what we've heard so far today is that international humanitarian law should already oblige a general exemption for politically neutral activity. Mr. Khan spoke about kind of a workaround involving money donated from other sources. That may not be an option that works for every organization. And I'm curious for the folks at Islamic Relief and World Vision, what's your view on the proposition that you may already have legal authority based on international humanitarian law to proceed? Is it just a matter of not wanting the legal headache of potential prosecution given the ambiguities?
Thank you for the question. I think from our perspective, it's important that we understand that each agency makes its own legal and risk analysis and assessments. And even though Islamic Relief was still doing projects in Afghanistan, for us, it's important that a lot of our colleagues in the sector have funds available for Afghanistan, but because of the risk of prosecution and their own risk assessment, they weren't proceeding.
Right. So is it fair to say that although the law may be on your side in general, there's some risk of prosecution, and that risk is unacceptable for? I mean, understandably, people who are involved in humanitarian work don't want to take on a risk of getting prosecuted.
I think 2 points. As Usama said, every organization has a different risk appetite and arrives at conclusions regarding risk in a different way. So for World Vision Canada, there was a decision that we wouldn't find either workarounds or that we could have through our global partnership or any other way. So we halted both public as well as privately funded activities in Afghanistan, while the World Vision Partnership, which is funded in sort of a pooled funding mechanism, was able to continue. To the second point, I think it's really important to distinguish between activities that are protected, as MSF and others pointed out, under IHL. It's not the full spectrum of activities that are delivered in these kind of contexts. So if you look at the provision 83.032, parenthesis 1, that lists the activities proposed in the bill, that arguably provides a full spectrum of activities that you would do that aren't just the more narrowly defined life-saving humanitarian activities protected under IHL. What we're saying is you can do that. We want to be able to continue, in the case of World Vision Canada, work that is focused on educating children, work that is focused on advancing the rights of children that don't have those IHL protections. So without the bill, we wouldn't be able to continue to do that. I don't think it's binary, right? You shouldn't be saying this is an either or choice. You can arguably do both. And that's, I think, where the conversation around a pure humanitarian exemption is important to have. We would submit that the list of activities is a really core thing, and anybody that has engaged with us over the last year was a key argument that we made. We cannot just focus on, we should be more exhaustive in what we're able to do.
Yeah. Okay. I think that's an important distinction. So maybe groups that are engaged in emergency humanitarian relief, they have greater, clearer protection of international law and may feel that they're taking less risk on. But if you're involved in longer term development oriented activities, Ms. Salahi, thank you for your testimony. I want to just get your perspective on, I think there would be some people that would be afraid that the engagement involved in delivering aid will provide some legitimization to the Taliban. Of course, the Afghan people are the primary victims of the Taliban. What do you think the people of Afghanistan would want us to be doing in terms of that potential balance between allowing aid to come in, but also not wanting to in any way contribute to the legitimization of this group that is not a legitimate government and that should not have the power that it does?
Thank you. I think we have a core principle for humanitarian aids. That's neutrality, and partiality is the part of it. So since we have this principle, under this principle, I don't think that it can be channeled toward the legitimacy. If we see the black and white, there is no black and white. We can decrease the regime role to zero. And any situation, even in an ideal situation, the regime will benefit from some of the aids, even in the tax style, or even the Taliban now they are doing a different role. For this instance, I think there's a different mechanism. For example, UN is a great mechanism because they are not providing tax, or they are not giving tax. So I think there's a different ways we can adopt. By adopting this way, we can decrease the role of regime, but we can't zero their role in it.
Thank you. Next, we'll go to Ms. Damoff for 5 minutes.
Thank you, Chair. Thank you to all of you for being here today, and thank you for the work you're doing. I do have to give a special shout out to Islamic Relief, who has their head office in Burlington, Ontario. So we had a lot of conversation, and some of you were here for it, I think, during the first panel about the blanket exemption for humanitarian aid. And Mr. Fisher, thank you for explaining a bit of the difference between life-saving humanitarian aid and broader development aid. Do you see a world in this bill where there's an exemption for humanitarian aid while still allowing groups like yourselves to apply for an authorization to do the work, or a group like Canadian Women for Women in Afghanistan, who've been operating in Afghanistan for decades and doing really good work?
I'll throw that to Amy.
Yeah, and I think that is a really important clarification. And I would say, there's IHL, and then there's life-saving assistance, and then there's the activities of the bill. And so the coalition is looking at that broader piece. And so the other thing that we would put forward is, in terms of what we would, and you won't find the sector disagreeing on the outcome. I think that we just disagree on the process and the time frames. And so I think that what we would put forward is that we'd like to see the language of the bill go forward so that we can resume our operations that are critical and life-saving. And then we'd like to have commitment to the journey, which would be, beyond IHL and then beyond to development and then looking beyond an authorization regime ultimately.
If I can just throw some of that question back to the government. Because it's ultimately, the bill that we have before us is the bill that we have before us for reasons that we heard on Monday, I think, both from Minister Mendicino as well as the officials. If there's a legal as well as a political way to insert that exemption, by all means, nobody, I think, on this table is going to say don't do that. What we're saying, though, is that that shouldn't be the litmus test of whether this particular a fine-tuned version of C41 should proceed. And just to reiterate, we also have the position that the two aren't mutually exclusive. You can do them in a sequence kind of way. But really, Mr. Moff, and we know each other well, it's really a matter of what the government intends to do. So we would strongly support, I think, what MSF and others said during the first session, that yes, if there's a way to do this, if it's ruled within scope during the amendment process, then by all means, please do it. But we would also urge, to turn the opposition, that that is not the litmus test of the bill. Right? There's other ways to improve the bill as it stands that makes it fit for purpose, as Amy said, that if that is done, that we should still proceed while seeking the long-term commitment to work towards an improved framework that includes an exemption. I hope that's good.
And you were the first one that brought this to my attention shortly after I was elected. So we have gotten to know each other very well over the years. Have you submitted to the committee all your recommendations? And so we'll be taking a look at those, but I think all of us want to get this done quickly because we want you to be able to deliver aid. And I know we heard earlier that MSF has still been operating, Islamic Relief is operating, but I also know that there's many, many organizations who are not. And people are dying because that aid isn't getting theirs.
I think one important consideration, we said while the bill is not about Afghanistan, it really is in the very short term. And I think an additional factor as you deliberate is that in our experience, there's very few contexts that garner the support from Canadians who are willing to stand up and be generous as Afghanistan does. So I think it's not just about whether we are able to continue doing our work, it's also whether Canadians and Canada as a whole, right, stands behind the commitment and the responsibility that it has because of our engagement towards Afghanistan. So it's difficult to separate the two out. It's difficult to not place it into a broader Canadian context, while also continuing to sort of have these more abstract conversations around IHL and how Canada can move towards a more comprehensive and robust regime more broadly.
Okay. I know I'm going to end it there because I won't have time to answer a question.
Okay, thank you. Next, we'll go to Monsieur Brunel Desepp for 5 minutes.
Thank you, Mr. Chair. Thank you to everyone who is here. Can everyone hear me? Great. I think that the Canadian Red Cross was consulted for drafting this bill. That's what the minister told us. Do you think that we listened to you enough during consultations?
So what I would say is that we feel well heard and we had lots of persistent engagement over the last year. In particular, the broad description of activities aligned to many of the recommendations that the sector and coalition made. And we feel as though it's been a really constructive dialogue in terms of the language of the bill. I don't know if my colleague Martin would like to add anything on behalf of the coalition.
Yeah, I mean, I pulled up the list of meetings that World Vision registered over the last 18 months, and it's unlike anything that we've ever done on any other bill. So there's across all parties, across departments, and I think there's limitations, obviously, once legislation gets tabled and once it gets drafted. Would we have liked to have been brought into the room at some point? Of course. But we also realize that there's limitations on cabinet confidentiality. In this particular bill, there's security limitations. So to Amy's point, there's a lot of language in the bill that came from submissions that we previously put in, and we feel heard. I think so.
Est-ce que le cabinet ou le ministre de la Sécurité...
Did the Minister of Public Security contact you directly for the bill?
His office, yes.
À quel moment il vous a contacté?
When did he contact you? Are you able to share that with us?
Throughout the process, and I think the details...
La première fois que vous...
The first time that you spoke, that his office contacted you for consultations?
I have to pull up my list. Either in February or March of 2022. Right around the time when the Special Committee of Afghanistan was conducting.
Okay, great. That's all I wanted to know. to know, rather. Now, if I understood correctly, and I mentioned this earlier, I'm sure you heard, that the most important goal is that we expedite the process of passing this bill. In your opinion, do you think the bill is acceptable as is right now? If the members of the government do not agree, would you prefer to see the bill remain as is today, or do you think it needs to be amended for it to be sent to the House?
I think that it would be substantially strengthened by some of the amendments that were discussed in the earlier session and are aligned to the coalition submission. But I don't think that any of them are not in keeping with the purpose or out of scope. And I think it would substantially make it better. And then we need to continue the discussion longer term.
OK, parfait, merci. Est-ce que...
Great, thank you. In your opinion, as the bill is drafted right now, if we take a hypothetical situation, say there's an earthquake, a major earthquake in a region that is controlled by terrorist entities, would this bill, as it is currently drafted, allow us to do the work we need to do?
It's what I would say is that it'll come down to the administration. So, and that's why we focused our intervention on how it will be administered. And so if there's proper resourcing and if we see what we've seen in the sanctions regime, it would enable us to resume life-saving or to provide life-saving assistance in that context, yes, where we wouldn't be able to now.
OK, rapidement, est-ce que...
Okay, very quickly. I just want to know, what is most important for you? Amending the bill or expediting its adoption?
I don't think the two are exclusive. I don't think they're mutually exclusive. I think there's amendments on the bill that are deemed by legal counsel and our organizations within scope. I think rarely is a bill tabled in perfection on the first instance. So I would urge everyone around the table to look at the amendments that have been pulled forward by the organizations that are going to be subject to the bill and look at them in good faith and have a conversation before Monday when clause by clause starts and find agreement.
Thank you. Thank you, Monsieur Duceppe. We will now suspend, and I'll get Ms. McPherson when we come back, till 10 minutes after the vote result is made. Thanks. If I can have everyone resume. We only have House resources till 7, so I just want to make the maximum use of our time. So I will, if we have everybody here, yeah, I'll have, we'll begin the last person from the first round with Ms. McPherson for 5 minutes.
Chair. Thank you to all the witnesses for being here today and for the important work you do. Thank you for your words on the women and girls in Afghanistan. I think I speak on behalf of all of us at this table that is the ultimate goal, is to ensure that there is help. One thing, though, I think that it's important to recognize is that this is not just about Afghanistan, and this is something that will have decades-long implications. Another thing I wanted to just comment on, if I could, Ms. Avis, you spoke a lot about commitment to the journey and the next steps and whatnot. Unfortunately, as parliamentarians, we don't vote on next steps. We don't vote on journey. We vote on legislation that's before us. And this legislation has an awful lot of ifs in it, an awful lot of a lot of things that make me question whether it's fit for purpose. You know, I worked in the sector for a very long time. I understand how long it takes to get policy from Global Affairs, get things through Global Affairs Canada. The ability of them to make decisions fast enough for a humanitarian context, I'm deeply worried about. We heard from testimony just a few days ago that they would consider 6 months a long time for this, but they didn't put it out of the wheelhouse. 6 months in a humanitarian context is basically useless. It becomes basically useless in many contexts. We waited 18 months for this legislation. It gives you an idea of the understanding of the urgency. So when we talk about a commitment to journey, when we talk about whether or not this government is fit for purpose to actually implement the bill that they've put before us, I think we have, or the NDP has, some very, very serious concerns. So there's a couple things I would like to start with, I guess. One is, we worry about timing. We worry about how this will be implemented. We are bringing forward some amendments. We're bringing forward an amendment for a humanitarian carve-out. For example, exempting from authorization process humanitarian assistance activities conducted under the auspices of impartial humanitarian organizations in accordance with international humanitarian law. Obviously, this would not cover the entire range of activities that the organizations represented here do, and I think we've heard the difference between humanitarian and development. But this would simply carve out for those activities. Would your organizations, and I'll ask the three of you, be supportive of that sort of an exemption?
Yes, absolutely.
Yeah, I think that, as we said that in our testimony, we're not against that type of an exemption, and we think other tweaks would substantially strengthen the bill. I think as long as we're committed to that path of expediency.
Well, we can't be. It's the government's role to have that thing, and so we can commit all we want, but if the legislation doesn't explicitly have, I have some challenges with that too. But yeah, sorry, Mr. Fisher?
Yeah, I think you can do both.
Okay, thank you. With regards to the work that your organizations are doing in the field, if you could speak very briefly about what this would look like. I think we've become very focused on Afghanistan because, of course, that is the impetus for this bill and what we've been calling for 18 months. But we all know that organizations work in multiple situations where humanitarian aid, international development are all required. Can you talk a little bit about the implications of this bill with regards to your work in other areas? For example, Gaza, Nigeria, Mali, the Central Africa Republic, Sudan.
Sure, I can begin. I think the bill as it stands, if it became law, we would obviously do a analysis, and the prudent approach would be, in a lot of contexts, to pause projects until we can get authorization. And that may include, in Palestine, possibly Yemen, possibly Syria. That analysis would have to happen. So I think immediately activities would have to be paused and information would have to be gathered on making this application. And so I think that would have a negative effect.
Just really quickly before I ask the other two witnesses, you said Palestine and Yemen. So currently right now we are selling arms to other sides of both of those conflicts. So the potential for that to be politicized is quite high, then, wouldn't it be?
Yeah, and maybe I want to mention, I think those names just came up because the onus right now is on the organizations to determine if they're listed by what definition. I think that's problematic because it's not coming from the government, and I think that's one of the recommendations that for modifications. So each organization would do its own risk assessment on does this geographic region, is there significant influence or controlled by listed terrorist entity, and that in itself again is problematic. And then once they do that, the process, initiating the process paperwork to start negotiating with the government to get that approval, I think it would add a lot of bureaucratic burden, red tape, administrative burden, and that's on top of all of the other CRA regulations that charities have to comply with within Canada, which is more cumbersome than any of our other partners in the EU or the US.
Thank you.
Means people's lives are at risk.
Thank you.
I'll have to get to the other witnesses at the next round.
Thank you, Ms. McPherson. Next, we'll go to Mr. Brock for 4 minutes.
Passing it on to my colleague, Mr. Ingenious.
Thank you, Chair. Mr. Khan, just to start off with, did I hear you right that you said if this legislation passes, you will have to pause projects that are currently underway in order to seek the authorization?
Yeah, I
Okay.
think if the bill is law, then from a risk analysis standpoint, if we assess that some contexts have a significant influence from listed entities, then the prudent thing would be to pause and to get that permission before.
Even though under the current legal framework, you feel comfortable carrying on those projects based on your risk analysis.
That's correct.
Okay, that's really important for us to know, because it maybe counters the rush it through even if it's not perfect message, but it's something we've all got to think about. Another question: we've had amendments put forward to be considered that involve limiting the scope of this bill to certain geographic areas that would be defined by the government, or limiting it to terrorist entities only, not terrorist organizations in general. This would provide greater certainty for the sector. But it raises another potential problem, which is that if there is territory that is controlled by a terrorist organization, not an entity, or that a territory that is controlled by a terrorist entity that is not listed as part of that listing process, then, as I understand the legislation, then you wouldn't be able to apply for an exemption in that case, and you would simply be excluded from doing work there. So that providing that list could narrow the places you could apply for an exemption, and therefore prevent you from doing any kind of assistance or support in other areas. So that raises some potential concern for me about those amendments. Do you want to respond to that concern? Go ahead, Ms. Avis.
So the current regime would apply generally, so we would be able to undertake our activities in the vast majority of contexts globally. In a circumstance in which there's sufficient, and again, I really want to reemphasize that for us, a critical amendment that we're looking for is that substantial control piece. In a situation of sufficient or substantial control, that is the limited circumstance in which we would have to apply, to which the authorization regime would be applicable. So we're talking in all the contexts, it's only where there's substantial control, and where there's substantial control we would have to apply. It is true that we're seeking further clarification by saying listed entities is more clear than terrorist generally. And so some of the amendments in our proposition are to tighten the limited circumstance that we're really talking about here today.
Unless I didn't follow, I don't know that really answers, though. Like, I'm concerned about a case where if we limit this legislation to only listed entities, and there's a place that is controlled by a terrorist organization that is not a listed entity, you can't apply for the exemption because it
would be permissible.
It would be permissible.
Yeah.
It seems that has to be clear that it would be permissible, because right now under the criminal code, it would not be permissible.
Would be so under the current criminal code, and maybe my colleague wants to expand. So under the reading of the bill, as the coalition reads it, is essentially in the vast majority of contexts we're able to undertake our work. And if you were to accept amendments to allow for the definition of listed entities, it would mean in even more circumstances we wouldn't have to apply. We would only have to apply in the very narrow circumstance in which it would be in our case, substantial control of listed entities, and so that's where the authorization would apply.
Assuming it's permissible in cases not covered by the regime, then why don't we just not create the regime?
So, I mean, I think that the legislation was seeking to provide clarity and assurance in situations like Afghanistan, which are very extreme, at every turn, you are wholly unable to not interact with a listed terrorist entity.
There might be cases where that same reality exists, but not because of a terrorist entity, but a terrorist organization that is not an entity. And you're saying you'd be assuming that activity is permissible if they're not covered, if they're not, that area is not identified. But if you're assuming it's permissible in that case, why would that be? Why would you make that assumption if it's not explicit in law?
So the legislation, the bill as it currently reads, doesn't use listed entities as like a defined concept. And so it truly is it's trying to talk about a circumstance in which it's completely, wholly, entirely unavoidable. And so in the circumstance you're describing along that continuum, that's not what the current, like a multitude of other regulations and safeguards enable us to work in that jurisdiction in keeping with our commitments and providing international humanitarian assistance. And so this bill is seeking to talk about the very narrow circumstances that are currently prohibited under the criminal code, which is a context like Afghanistan, which is very extreme. So
Thank
everything
you.
else is permissible.
Thank you, Mr. Genius. And just for the record, Mr. Genius, I gave you over 5 minutes, so I will be giving the next person 5 minutes as well. Mr. Nakvi, 5 minutes.
Thank you very much, Chair, and I want to thank all the witnesses for being here today, and thank you for your very engaged conversation. Last time I spoke on this issue was when Minister Mendicino was at the committee, and I'll ask the same question that I asked him, because that's the struggle that I'm having in my mind, and perhaps I'll start with Mr. Khan and then we can move down the chain, and that's around how do you balance between concerns around an entity or regime like Taliban, which is extremely oppressive in nature. It is the things they're doing, have done, their views around women is abhorrent to me personally, and I'm sure to Canadians. Not to mention some of the practices they deploy and undermining decades of work that has been done in Afghanistan in terms of giving women more freedom, ensuring there's education and important development work, which all of you have been part of. And you juxtapose that with the humanitarian crisis that's taking place right now in Afghanistan since Taliban has come into power, and the state of affairs there as it relates to people. So as a government, as policymakers, when we're trying to ensure that money doesn't go in any way to Taliban, but while also we are able to help people, I just want to hear from you as to what is the best possible way to meet that right balance, which would we try to accomplish. Start with Mr. Khan.
Sure. Thank you for the question. I think it's important. The most important stakeholder in this, I think, is all the women, girls, and people that are struggling in Afghanistan and that need help. And placing them at the heart of the discussion and finding solutions on how, as Canadians, we can reach them and make sure that generous Canadian donors, how we can, in a trustworthy way, take their donations and be that bridge. But I think I can speak for all the humanitarian organizations represented here. These are sophisticated operations. It's not the only context that we've been dealt with a similar situation. And the policies and the judgments and the expertise that has been gained, I think sometimes we overblow the perception that a significant diversion of funds will happen to the government. And, in this example, because I had looked into it, only 3% of the funds were going as taxes to the government. And I think that's reasonable in terms of, so we didn't feel that an undue influence or undue diversion of funds was happening to the Taliban government. And so I think putting that onus on the agencies to make that judgment call where, if more than 50, 60% were going, I don't think any of the agencies would proceed in getting that access.
So you have internal mechanism by which you make a determination. We're no longer going to operate in a particular jurisdiction because we don't feel comfortable as to where some of hard-earned or raised donation dollars may go.
Absolutely. I think the donors that give us the money, we take that custodianship seriously. And so if we feel that the money which is intended for women and girls and the people, if that's not going there, then we would pull out, cease operations, find a different geographic area within the country or demographic.
Can I hear from Red Cross in terms of your views, in terms of the balance we're trying to accomplish through this legislation?
I think the other, and I'll speak on World Vision's behalf, the other consideration is that at least the three organizations that are sitting here and many of the other organizations operate in these large international federations or partnerships in which we have very strict guidelines around risk tolerance and around sort of what Usama was talking about. So it's not just, ultimately, yes, World Vision Canada makes a decision on whether or not risk tolerance the risk is acceptable to us or not. But there's also an international component in there that provides additional safeguards where our partnership provides sort of guidance on, well, this context is, I'll be more colloquial, it's too tricky, it's too risky, right? We cannot, and again, we cannot operate. And again, I think that's, different organizations will come to that conclusion at different levels, right? And I think there is no right threshold, whether it's 3%, 5%, 7%, 14%, when you hit that determination. What I would say, two concluding remarks, we're driven by the humanitarian imperative. And the humanitarian imperative obliges us to take risks in order to deliver humanitarian assistance. So, but when those risks, when we perceive that those risks put our ability to provide assistance elsewhere because of the legal parameters that we operate in within Canada, then you'll have that kind of consideration. And I think the second piece, we said this at various stages, it's not just Bill C-41 that is that provides the regulatory framework for charities and humanitarian organizations in Canada to operate in those kind of contexts. Right? We have donor at the very top. We have donor promise where we have to, as Usama said, provide Canadians certainty that what they are giving us the funds to is actually what they're being used for, and then very clear down to reporting with the CRA and elsewhere. So it's not just C-41. You have to place that into a larger context.
Thank you. Thank you, Mr. Naqvi. And we'll go for our last 2.5-minute rounds each for Mr. Brunel Desep and then Ms. McPherson afterwards. 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. So we agree on one thing. Like my colleague said, I think everyone's been saying it. We're all here because we want to ensure that Canadian organizations be able to do the work on the ground that's necessary to help people. If there are new crises in areas that are controlled by terrorist organizations, we want to be able to do our work. Canada has been a leader in this field, and right now we're facing a legislative crisis, and we don't have unanimous consent. We don't have agreement with the government, with departments, with NGOs, but we need to come to an agreement. And what I would like your help with as an MP is how can we get everyone to agree on a decision, because you are the experts. So how do we do this?
By finding consensus where there can be consensus, by recognizing that, again, coming back to Afghanistan, that the urgency perhaps in Afghanistan bestows upon everyone to make more compromises than in a different context. And by listening to the experts, I mean, you have heard from a variety of organizations, but I think there's actually agreement. I think there's agreement, at least from experts, that you can do both when it comes to the blanket exemption that's being proposed while fine-tuning C-41. That's the ideal case scenario. I think that's emerging after today. So we can try our able best, and we will do that. Right? I think everybody, including MSF and others, who to continue to engage with you over the next coming days. And if we can be helpful in those deliberations, we'll obviously continue to do that.
Et ça, c'est le meilleur scénario. Le pire des...
That's the best case scenario. The worst case scenario would be that we waste our time and we don't come to an agreement. Do you agree with me on that statement?
100%. Yeah. It's not the place to filibuster.
Thank you. Last to Ms. McPherson for 2.5 minutes.
Thank you. So the representatives here are from larger organizations that do this work. And in fact, all that did the briefing note are relatively large organizations. Do you worry at all about the implications on smaller organizations that do work in the field? You know, Canadian Women for Women in Afghanistan is a perfect example of a small organization. This is a very burdensome process for smaller organizations. Anyone like to comment on that?
We do agree, and that's something that we're concerned about. And as a sector, it is in keeping with other kind of application-based regimes that we have to contend with. Like, this isn't unique. This is something we're familiar with. And we do believe that we'll support one another in the process. And I would just say to the earlier comment that the express humanitarian carve-out won't solve that problem. Those aren't the small organizations. That's, what we're talking about isn't going to solve that problem for them.
The humanitarian carve-out.
It will not.
No. I know
Yeah.
this legislation in itself will be a barrier for those organizations, and the process by which we are asking them to go through additional bureaucratic processes in order to be able to work in some of these regions. Yeah, I guess, one other, or sorry, Miss Avis, there's one other question that I have for you. We received testimony, we've received testimony from the Canadian Red Cross. The International Committee on Red Cross does not support this legislation and actually says that it is in counter, it is in opposition to international humanitarian law. Why the discrepancy?
I think that we're actually aligned. I think that we both submitted that an express humanitarian carve-out is something that we'd all want. I think that we're aligned that we need to systematize neutral and impartial humanitarian assistance. I think that the Canadian Red Cross is subject to domestic Canadian laws and is unable to operate in Afghanistan, and this bill is a reasonable step forward.
So what I'm hearing from that is that because the International Committee on the Red Cross is not part of the legislative framework of Canada, they look at this legislation and say that it's bad. But because you need to work within the Canadian legislation, you're willing to accept this legislation.
No, as I said, we all believe in a blanket carve-out for international humanitarian law. That's their submission. And so if that was considered or taken forward, which we also have in our testimony today and in our written submission, we're completely aligned on that point, and that would solve their problem, essentially.
If I can, thank you, Chair. If I can just, I'm obviously not speaking on behalf of the Canadian Red Cross, but I think where the conversation has evolved over the last few days is just C41 is insufficient. And I think seems to be, and I think that's the position, right, that initially, in my interpretation from the ICRC, if there were not room for an additional humanitarian carve-out, and if C41 passes unamended, then that's not ideal. And I think that's where consensus has emerged from all witnesses, and I think that's fair.
Thank you. Thank you, Ms. McPherson. I want to thank the witnesses for your great testimony and the great service that you and all your organizations do for humanitarian efforts around the world. It's very commendable. I want to thank all my colleagues here in the room, especially those visiting, for being very timely and being able to adjust even with the votes in between, and we're able to get a good, decent round of questions. So thank you very much, and we'll now adjourn.